Hi. So in civil cases, there will be two steps. One is pre-decree proceedings, the other is post-decree proceedings. Pre-decree proceedings are the proceedings which decide who is the winner of the case. Post-decree proceedings are the execution proceedings. Now, execution proceedings are of broadly three types. That is the arrest, the attachment and sale of movable property, attachment and sale of immovable property, that is plot, house, apartment, lands, etc. Now, mere procuring a decree from the court is of no use. If plaintiff files a suit against the defendant and plaintiff wins the case, it is called suit is decreed. If suit is decreed, plaintiff files the execution petition and plaintiff becomes judgment creditor or the decree holder. If suit is dismissed, defendant becomes the judgment creditor or the decree holder and plaintiff becomes the judgment debtor. I'll repeat once again. If suit is decreed, plaintiff becomes judgment creditor, defendant becomes judgment debtor. If suit is dismissed, defendant becomes judgment creditor and plaintiff becomes judgment debtor. So if suit is dismissed, defendant files an execution petition, and if suit is decreed, plaintiff files an execution petition, and the execution petitions are of majorly three types. Now, arrest and attachment of movables, attachment and sale of movables doesn't have much problem, but attachment and sale of immovable property is more complex. Today, I am going to share with you about how to stop a sale. Because once sale happens, you can't, court sale is the best sale. If the sale becomes absolute through the court proceedings, you can never recover it back to the same position. So to understand how to stop a court sale after attachment, you must understand the procedure of the sale. So to understand the procedure of the sale, you must understand the pre-sale proceedings, which are nothing but the attachment of the property. So in the execution of the decree, once execution petition is filed, praying the court to attach and sell the EP schedule property against which attachment is sought by the decree holder, court requests for a counter from the JDR or the judgment debtor, and prima facie decides that the property can be attached. So further, decree holder has to submit the property documents along with encumbrances, and the property is checked by the court for the schedule and the boundaries, etc., and the encumbrances, etc., and if everything is in order, gives a provisional order for attachment or issues a warrant for attachment. So that warrant will be taken to the EP schedule property and checked for the boundaries, checked for the location, checked for the existence of the property. Panchanam is conducted and provisionally it is attached. So once it is attached, court gives an opportunity for the judgment debtor to come to the court or to have a say in the attachment proceedings. So once judgment debtor speaks about his version of attachment or his objection to attachment, court decides the finality of the attachment and passes a final order for attachment and informs the sub-registrar office, revenue authorities if it is an agricultural land, or municipal authorities if it is a city property. And by the beat of drum or any other customary mode, if it is in a village, and if it is in a city, to the apartments association or the colony association, etc. Once that is done, attachment is completed. Now the next step is the most important step, which is the sale procedure. Most complex procedure in the entire civil procedure code, to my understanding, is the sale procedure. So to sell the property, court will not sell it just like any other common man. Court will take all the precautions because many factors are involved in selling the court property. The point number one, court will ascertain the market value of the property from the decree holder, market value of the property from the judgment debtor, market value of the property from any other source by appointing an advocate commissioner, If still it is in dispute, market value from the sub-registrar, that's a government market value, open market value, mortgages, encumbrances. There are 6 types of mortgages. So mortgages, encumbrances, rights, joint property rights, ancestral property rights, self-acquired property rights, loans, bank loans, etc., etc. All these terms are taken into consideration. And court will settle these terms in the proclamation notice. Proclamation notice means a notice which contains the date and the place and the details, the terms and the conditions of the auction, the proclamation, the details of all these encumbrances, etc. So this is the most important step which court takes up, that is called the settling the terms of sale proclamation. Once these terms are settled, there will be objections from the judgment debtor, there will be objections from the third parties, there will be objections from the banks, there will be objections from mortgagors or mortgagee. All these factors are taken into consideration and the terms of proclamation are settled. Without settling these terms of proclamation, court will not proceed. So, if any defect is there in settling the terms of proclamation of sale, sale will stop. So, after settling the terms of proclamation and sale, court will conduct an open auction and court will sell. Auction procedure is very simple. But again, if there is any claim from the third party, if there is a claim from the purchaser, if there is a claim from the bank or any other claims, third party claims, then sale process stops. In the meanwhile, if JDR comes forward and pays the money, then also sale process stops. So sale is a complex thing. Sale is a most important and dealt very carefully by the civil procedure court. And ultimately, when the property comes out of all these hurdles, sale is made obsolete. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.